La Cour
Seated. I declare open the public hearing on the admissibility and merits in the case of Yalçınkaya against Türkiye. The application was lodged with the court on the 17th of March 2020 under Article 34 of the Convention by a Turkish national, Mr. Yüksel Yalçınkaya. The application was allocated to the second section of the court pursuant to Rule 52, paragraph 1 of the Rules of Court. The application was communicated to the government on the 19th of February 2021. The President of the Chamber granted leave to the International Commission of Jurists under Article 36, paragraph 2 of the Convention and Rule 44, paragraph 3 of the Rules of Court to make written submissions to the court as a third party. The intervener remains a third party in these proceedings. On the 3rd of May 2022, the Chamber decided to relinquish jurisdiction in favour of the Grand Chamber. The respondent government are represented by their co-agent, Mr. Haji Ali Achigul, Head of the Department of Human Rights of the Ministry of Justice of the Republic of Türkiye, assisted by Mr. Stefan Talmon and Mr. Christopher Stoker, counsel. The applicant is represented by Mr. Johan Heijmans and Mr. Johan van der Lanotte, counsel. I welcome the representatives in the name of the court. Having consulted the co-agent of the government and the representatives of the applicant, I have determined the order of address as follows. Mr. Achigul, Mr. Talman and Mr. Stoker for the government will speak first, and then Mr. Heijmans and Mr. van der Lanotte for the applicant. I give the floor to Mr. Achigul.
Madam President, honourable members of the Grand Chamber, this case concerns the applicant's criminal conviction of membership of an armed terrorist organization. The issue for the court is whether the criminal proceedings in his case involved violations of Articles 6, 7, 8, and 11 of the Convention as alleged by the applicant. The government denies that this is the case. The court will be aware that his proceedings took place in a broader context. The armed terrorist organization was Fetullahçı terrorist organization known as FETÖ. This organization has been found by the Turkish court to be responsible for the violent coup attempt on 15 July 2016, in which 252 people has lost their lives and thousands were injured, including mainly civilians. Fighter aircraft bombed the National Assembly while it was still in session. Ships, tanks, and heavy artillery were also used. There is no dispute that overthrowing the constitutional order of a state by force amounts to armed terrorism. The applicant's conviction was based mainly on his use of the encrypted messaging service ByLog. The trial courts found ByLog to be exclusively used by FETÖ members. Although many others have also been convicted of membership of this organization, this case is neither about the organization nor about Turkish politics or about the Turkish judiciary in general. It's about alleged violations of the Convention in the proceedings against this particular applicant. The evidence before the domestic court showed that the applicant used bylaw in October 2015. Although this was before the attempted coup, by that time arrest warrant had been issued for Fethullah Gülen and other members of the organization for establishing or leading an armed terrorist organization. In fact, already from 2013, investigations into the organization had commenced and had become a matter of public knowledge via the media. I refer the court to the arrest warrants and press reports submitted on 24th December 2022, expressly referring to FETÖ as an armed terrorist organization. The written text of our speeches provided to registry yesterday contains footnote reference to all the documents referred to. By October 2015, members of the public would have been aware that this was an armed terrorist organization, but in any event, any member of the organization couldn't have been unaware. The attempted coup was a public emergency threatening the life of the nation within the meaning of Article 15 of the Convention. Türkiye duly informed the Council of Europe of a derogation under that provision. The derogation was enforced until 8 August 2018, after the judgment of both the Assize Court and the Regional Court of Appeal had been given in the applicant's case. Turkey relies on that derogation, but its principal submission is that there was no departure from the Convention guarantees in the present case. The government would also like to reiterate its objections with regard to the admissibility of certain of the applicant's claims set out in detail in paragraph 108 to 132 of its observations dated 21 September 2021. The government also maintains all of its written observations regarding the merit. We address only key points today. Professor Talman will address you on the issues arising under Article 6 of the Convention. Dr. Staker will then address you on the issues arising under Article 7, 8, and 11. I thank the court for your careful attention. Madam President, I invite you to give the floor to Professor Talman.
Professor Talman.
Madam President, distinguished members of the court, it is an honor to appear once again before you and to do so on behalf of the Republic of Turkey. This is the first time that issues concerning the use of bylaw arise before this court in the context of Article 6 of the Convention, rather than Article 5. In this case, the question is whether the applicant received a fair trial, not whether there was a reasonable suspicion of him having committed an offense. The court's earlier bylaw case law under Article 5, therefore, can be distinguished both on the facts and the law. The central issue under Article 6, paragraph 1, the requirement of a fair hearing, concerns the domestic court's assessment of the evidence and its finding that the applicant used bylaw, and that this use of bylaw, together with other evidence, established his membership of an armed terrorist organization. It is well established that the court has no jurisdiction to substitute its own findings of fact or law for those of the domestic courts, which are in the best position to assess the evidence before them and apply the relevant domestic law. This court is not a fourth instance body. In Bochan versus Ukraine number 2, the Grand Chamber held that Article 6, paragraph 1 lays down no rules on the admissibility of evidence or the way in which evidence should be assessed, these being primarily matters for regulation by national law and the national courts. Normally, issues such as the weight attached to a particular item of evidence or assessments submitted to the national courts for consideration are not for the court to review. Only decisions that are arbitrary or manifestly unreasonable may be found incompatible with the guarantees of a fair hearing. The threshold for a finding of arbitrariness or manifest unreasonableness is very high indeed. The court has required a manifest error of assessment, that is to say, an error that no reasonable court could ever have made. The unreasonableness must be striking and palpable on the face of it. A domestic judicial decision cannot be qualified as arbitrary to the point of prejudicing the fairness of the proceedings unless no reasons are provided for it. If the reasons given are based on a manifest factual or legal error, if the reasoning disregards the bulk of the evidence presented, or if the decision fails to connect the established facts, the applicable law, and the outcome of the proceedings. None of these requirements are met in the present case. The inferences made by the domestic courts were not manifestly unreasonable or arbitrary. There are no objective reasons to call into question the assessment made by the domestic courts. Indeed, the trial court's assessment was shared by all other Turkish courts assessing the evidentiary value of the use of bylaw, including the Constitutional Court. In Ferhat Kara, the Constitutional Court held that the applicant's conviction for his membership of a terrorist organization based solely on the use of an encrypted communication network cannot be considered a manifestly arbitrary practice. Can it seriously be argued that all Turkish courts acted unreasonably? This court itself, in Akgün versus Turkey, held, and I quote, "The use of electronic evidence indicating that an individual availed himself of an encrypting messaging service which had been specifically designed for and exclusively used by a criminal organization for the purposes of that organization's internal communication could provide a strong indication that that individual belonged to such an organization." End of quote. The court thus accepted in principle that inferences with regard to membership of a criminal organization may be drawn from the use of an encrypted messaging service that was exclusively used by the organization. Both the Kayseri Second Assize Court and the Ankara Regional Court of Appeal expressly found, after a detailed examination of the electronic, technical, and other evidence, including expert reports and confessions by FETÖ members, that BILOG was used exclusively by members of FETÖ with a view of ensuring secret communications within that organization. In addition, the Ankara Regional Court of Appeal expressly relied upon the decision of the 16th Criminal Chamber of the Court of Cassation in the case of Baja and Öcalan, which had only been given 5 months before. This 201-page long, extremely thorough decision, which was confirmed by the plenary session of the Court of Cassation, Turkey's highest court in criminal matters, established after lengthy examination of the evidence that BILOG was used exclusively by members of FETÖ. The Court of Cassation also explained in detail the evidential value of the use of BILOG for proving membership of a criminal organization. In Akgün versus Turkey, this court said that where electronic evidence such as BILOG data is used as the sole basis for establishing membership of a criminal organization, the National Court has to have available sufficient information about the material in question before examining its potential evidential value under domestic law. The extensive expositions on BILOG clearly show that the trial courts had sufficient information about the material. In any case, the use of BILOG was not the sole basis for establishing the applicant's membership of FETÖ. The trial courts also took into account that he was a member of associations and trade unions connected with FETÖ, and that he provided financial support to a bank affiliated with FETÖ in response to calls made by the leader of the organization for the recovery of the bank. Madam President, the court's task is to assess whether the proceedings as a whole, including the way in which evidence was taken, was fair. In particular, the applicant must have been given the opportunity to challenge the authenticity of the evidence and to oppose its use, and his defense submissions must have been properly examined by the courts. In addition, the quality of the evidence must have been taken into consideration, including whether the circumstances in which it was obtained cast any doubt on its reliability or accuracy. In adversarial proceedings, in which the applicant was fully involved and legally represented, he availed himself of the opportunity to challenge the BILOG evidence and oppose its use. He called into question the authenticity of the BILOG data, did not accept the various reports based on that data, and requested a fresh report. It is, however, a matter for the trial courts to assess the authenticity and evidentiary value of evidence, including electronic data and expert reports. As stated by this court in Ayatollah A versus Turkey, the mere fact that the trial court relied on the opinion of a particular expert does not reveal any unfairness. The court also held in PW versus Austria that Article 6, paragraph 1 does not impose on the trial court an obligation to order an expert opinion or any other investigative measure merely because a party has requested it. Thus, the Kayseri'de Assize Court rejected with reasons the applicant's request to submit the BILOG data pertaining to him into the case file. And the Ankara Regional Court rejected the request for another report on the BILOG data. The applicant also put forward the argument that the BILOG evidence could not be used because the BILOG data had been obtained illegally, including in breach of the right to respect for private life. Both the Kayseri Assize Court and the Ankara Regional Court of Appeal rejected this argument after establishing the legality of the acquisition and use of the BILOG evidence. The legality of obtaining the BILOG evidence was also confirmed by the Court of Cassation. In addition, the Ankara Regional Court of Appeal expressly addressed the question of the quality of electronic evidence such as the BILOG data. Madam President, as to the applicant's claim that he was not tried by an independent and impartial tribunal established by law, this has already been dealt with by this court before. In Baja and Öcalik versus Türkiye, the court held that the decision of the High Council of Judges and Prosecutors that the second assize courts could specialize in dealing with terrorist offenses was in accordance with Article 6. The applicant has failed to substantiate his claim that the judges of the second Kayseri Assize Court or any other judges seized with his case lacked impartiality. As in the case of Bash versus Turkey, the applicant's submissions amount to criticism of the judiciary in general and do not concern the judges involved in his case specifically. These judges enjoyed the same constitutional and legislative guarantees ensuring their independence and impartiality as all other judges. Moreover, there is no indication of any prejudice or bias on the part of the judges as regards the applicant's personal circumstances. This complaint should therefore be rejected as being manifestly ill-founded. In conclusion, no unfairness resulted from the use and assessment of the BILOG evidence. There is also no basis for the claim that the applicant was not tried by an independent and impartial tribunal established by law. The applicant's claim with regard to Article 6 should therefore be dismissed. I thank the Court for your careful attention. Madam President, may I now please ask you to call on Dr. Staker to address you on the issues arising under Article 7, 8, and 11.
Thank you. Dr. Staker, you have the floor.
Madam President, members of the Grand Chamber, I address Articles 7, 8, and 11. As to Article 7, the applicant was convicted of a crime expressly provided for in Article 314 of the Criminal Code and Articles 1, 3, and 5 of the Anti-Terror Law, which had existed in their present form for many years. These provisions make mere membership of an armed terrorist organization a crime. This is in itself inherently criminally reprehensible conduct. The legislation does not and need not make criminal liability dependent on the actual commission of crimes by the organization. criminal liability is not made dependent on the existence of a prior judicial decision declaring the organization terrorist. Being a member of such an organization is criminal, even if the authorities do not yet even know that it exists. The lack of such judicial decisions before October 2015 is thus immaterial. The Court of Cassation's acquittal of Fethullah Gulen in 2008 is also immaterial. That case concerned evidence and events up to 2000. It did and could not determine what that organization would be in 2015. The agent for Türkiye has referred to arrest warrants for Fethullah Gulen and press reports predating the applicant's use of bylock referring to FETÖ as an armed terrorist organization. By the time of the applicant's trial, there were judicial decisions declaring the organization to be terrorist. The applicant's indictment refers to a decision of the Erzincan Assize Court. In his subsequent proceedings, the Kayseri Assize Court referred to judgments of the Tokat Assize Court and the Samsun Regional Court of Appeal, while the Ankara Regional Court of Appeal relied on decisions of the Court of Cassation in the Başa and Özçelik case. This case is therefore different to Parmak and Bakir versus Turkey, where the court spoke about what domestic courts must do when confronted with the task of assessing for the first time whether an organization can be classified as terrorist. That is not the situation here. The Regional Court of Appeal found, based on earlier case law, that the organization's purpose was to take control of the country by force if necessary. It must have been reasonably foreseeable to anyone in October 2015 that an organization with those purposes would be an armed terrorist organization for purposes of the legislation. This crime has a specific mental element, or mens rea. The applicant was required to know the purpose of the organization. This was expressly acknowledged by the Ankara Regional Court of Appeal, which found that the applicant had that intent. The finding that the applicant had this intent was for the domestic court. As Professor Talman has submitted, this court is not a fourth instance and will not deal with alleged errors of fact by domestic courts unless they were manifestly arbitrary. They were not. The applicant was not punished for using bylock, nor was he punished for depositing money with Bank Asia or for being a member of a trade union and association. He was convicted of membership of an armed terrorist organization, namely FETÖ. His use of bylock and other activities were merely evidence of his membership of FETÖ. If a person is convicted of murder on the basis that their DNA evidence was found at the crime scene, they are not being punished for leaving DNA evidence. Here, bylock use and the other activities are like the DNA evidence. The convention question is whether the applicant could reasonably have foreseen at the material time that his membership of the organization would make him criminally liable, and not whether he could have reasonably foreseen the evidence or circumstances that might be used to prove that membership. As to Article 8, the BILOC raw data was first obtained by the National Intelligence Organization pursuant to Law Number 2937. It was obtained in accordance with the law. The evidence shows that the National Intelligence Organization, MIT, acquired some 109 gigabytes of BILOC raw data located outside Turkey. 109 gigabytes is about 1/10 of the capacity of a modern 1 terabyte laptop. This is not bulk data interception defined in Big Brother Watch as huge volumes of data. The raw data was encrypted and unreadable, and its contents were unknown. This was not a case of ongoing secret surveillance measures as generally understood. Any interference with Article 8 rights at that point, if any, was a minor interference and was justified under paragraph 2 of Article 8 in the interests of national security. Furthermore, on 9 December 2016, a judicial order authorized the analysis of the raw data for criminal justice purposes. The government says that the 9 February 2017 BILOC findings report was based on information extracted from the raw data pursuant to this judicial order. The Ankara Regional Court of Appeal said that the conviction was based on the internet and telephone records, the BILOC findings report, and the expert report. The BILOC findings report, as I've just indicated, was obtained pursuant to judicial order. As to the phone and internet records, by law, these are given by the private service provider to the Independent Information and Communications Technologies Authority, the BTK, which provided them to the court pursuant to a court order under the Criminal Procedure Code. The law on how long the data could be kept applies to the service provider, not BTK. Furthermore, even if BTK had been subject to the time limit and had exceeded it, this would not mean that it would violate Article 8 for the court to receive that material pursuant to a court order and use it. As to Article 11, the government's reading of the judgments of the Assize Court and Regional Court of Appeal is that the applicant was not convicted for having been a member of the trade union or the association. These memberships were merely circumstances that the domestic courts took into account when determining whether he was a member of FETÖ. The domestic courts were not penalizing him for having been a member of the other organizations, and accordingly, no issue arises under Article 11. For these reasons, no violations of Articles 7, 8, and 11 are established. Madam President, members of the Grand Chamber, that concludes the first round of oral observations of the Republic of Turkey. I thank you for your kind attention.
Thank you for your submissions. I give the floor to Mr. Heijmans.
Dear Madam President, dear honourable judges of the court, my name is Johan Heijmans, and together with my colleague Johan van der Lanotte, I will plead today before your court in order to defend the interests of Mr. Yüksel Yalçınkaya. I will concentrate on the questions of your court relating to the BILOC evidence affecting Articles 6 and 8 of the Convention, while my colleague will deal with the limitations imposed on applicants' freedom of association and on the lack of independence of the Turkish courts in the present case, affecting Articles 6, 7, and 11 of the Convention. Before I start, I want to emphasize that this case is of the utmost importance, not only for applicants, but also for the thousands of Turkish citizens who are also suffering from similar grave human rights violations and who are also confronted with arbitrary trials. Your court has often stated that justice must not only be done, but also seen to be done. But perhaps it is even more important that when no justice is done, that this is also seen. And that is exactly what is the case in the present application. Before I delve deeper into the contents of the case, I want to briefly address a procedural point that was raised by the Turkish government. Notably that not all violations which are addressed in the questions of your court have been raised by applicant in the domestic proceedings. That is simply incorrect, as is demonstrated by our Annex 1 to our summary. And that document clearly shows that all the points which are raised in the present application have been, at least in substance, presented to the domestic courts, or often explicitly by referring to the articles of the conventions before, notably, the Turkish Court of Cassation and the Constitutional Court. If there are any additional questions or ambiguities on this point, I will address them in rebuttals. Because today I want to focus on the merits of the case, since it concerns, as I already said, very grave human rights violations, and that is particularly true with regards to the use of the BILOG data. In order to briefly remind you of the pertinent context, BILOG is an encrypted application that could be downloaded by anyone all over the world through the Google Play and the Apple stores. Worldwide, 600,000 people downloaded this application through one of these stores. Still, suddenly, in 2016, the Turkish government suddenly decided that this application, and I quote, was exclusively used by FETÖ, which they considered to be a terrorist organization. And for that reason, the Turkish National Intelligence Organization, MIT, tried to get a hold of these data as quickly as possible. At this moment, we have no idea at all whether MIT managed to do so, and if so, how they managed to do so. The only thing we know for sure is that the servers of this BILOG application, that they were located in Lithuania, and that MIT claims that they have managed to collect the IP addresses and communications held by the BILOG users. In order to link these IP addresses then to concrete individuals, they relied on history traffic search records, HTS records, which were held on to by the Turkish Information Technologies and Communication Authority, called BTK. In the present case, applicant has always denied till today that he has ever used the BILOG application. The Turkish government claims otherwise and reproaches to applicant that he would have used the BILOG application on 6 days in October 2015. And it's that use of the BILOG data which eventually resulted as the decisive element to convict applicant to a harsh prison sentence of 6 years and 3 months. Now, as to the specific questions of your court regarding the Articles 6 and 8 of the Convention with regards to the BILOG data, there are a lot of questions, but perhaps in order to address them logically, it is best to do so chronologically by addressing the questions from the moment the data were gathered till the moment these data were used to convict the applicant. If you look at the stage before the proceedings against applicant even started, the BILOG data, again, if they were gathered, they violate Articles 6 and 8 of the Convention for 2 main reasons. The first reason being that these data, they were gathered in violation of the Turkish laws or in any event do not have a solid legal basis. As to MIT, we know that they claim that they have gathered these data in May 2016 without having a court order allowing them to do so. The court order only followed 7 months later, in December 2016. In the meantime, these data had already been used to deprive Turkish citizens of their freedom. And this notably happened to applicant who was put in pretrial detention on the 9th of September 2016, 3 months before the court order. Such actions are totally contrary to Turkish law. And it is clear that from this Turkish law that normally MIT, when they want to take an action, they need to have a court order beforehand, or if there is an emergency, that within 24 hours they need to rectify the situation and obtain such a court order. But that didn't happen in the present case. And Turkey is aware of that problem and therefore tried to fabricate a legal reasoning on an alternative legal basis, more precisely the Article 6, paragraph 1 of the law on MIT. But if one looks at that article, it is very vague, merely containing some definitions and general principles, and therefore can never qualify as a law in accordance with the strict jurisprudence of your court. In other words, such paragraph would allow MIT to do anything they want without any limitations or judicial control. And Turkey itself is aware of this, because in 2005 they supplemented this article with 5 additional paragraphs, notably providing these checks and balances and requiring explicitly that when MIT wanted to intercept communications, they need a court order. But still, MIT did not comply with these provisions, and also the Court of Cassation of Turkey completely ignored them. And the same applies with regards to the records, the HTS records, which were collected by BTK and the telecom operators. Both applicant and the government seem to agree that these records were held on to largely beyond the maximum retention period of 12 months. But the government says that that is not their concern, that this is the responsibility of the telecom operators. First of all, that is completely incorrect. What really happens is that the telecom operators, they gather these data, and when the maximum retention period is approaching, they transfer these data to BTK, which is a government institution, and it is then BTK which holds on to these data beyond the maximum retention period. But even if we would follow the Turkish reasoning, then still such reasoning would be way too easy, because that it would mean that states would just outsource all their illegal activities to private players and never be held accountable. And that would violate Article 5 of the ILC draft articles on state responsibility, but also go against the jurisprudence of your court, notably the Mutu and Pechstein versus Switzerland case. Moreover, holding on to illegally obtained data, which then the government eventually did, is a crime under Turkish law. Articles 135 till 138 of the Turkish Criminal Code. And the Turkish Constitution and the Turkish Code on Criminal Procedure explicitly provide that a criminal conviction can never be based on illegally obtained evidence, which happened in the present case. The second reason why the BILOG data violate Articles 6 and 8 of the Convention is the fact that we have no idea at all as to how they were gathered and how, consequently, their integrity was preserved. As to the way these data were gathered, we have multiple explanations. The judge, in first instance, in the present case, considered that these data were bought of Lithuania, but other documents claim that these data were stolen by MIT officials who went to Lithuania. In any event, however it may have happened, one thing is sure today is that we have no idea at all as to how these data have ended up, if they have ended up in the hands of MIT, how they have ended up there. And this casts a shadow of unreliability over the data in their entirety. And the same applies with regards to the way they preserve these data. The only thing we know for sure is that these data have been tampered with. In this regard, one can take a look at the report, the expert report of Professor Baha Sen and digital forensics expert Rafet Ongokmen, both appointed by Turkey itself, who confirm that the data have been manipulated on the 26th of October 2016 before there was even a court order. So even if today the government would suddenly come up with these original BILOG data, there is still no way to satisfy the chain of custody requirements that your court requires with regards to such data. Then if you look at the proceedings against the applicant itself, we clearly see that his right to a fair trial has been violated. Also for multiple reasons. The first ground being, and that is really crucial, that during the domestic proceedings, the communications that the applicant allegedly had through BILOG and the original BILOG data were not made available to both the applicant and the judges. The alleged communications that the applicant had through BILOG were only made available in this proceeding before your court under Annex 27, and so not before the domestic courts. And the original data set regarding BILOG has, in spite of the explicit request of your court, still not been made available to notably the applicants, but also not to your court. And this is really problematic because all those years the prosecutor has had this data, and he refused to disclose them to notably the applicant and the judges. And this is problematic because the only way for applicant to effectively defend himself was to have access to these two sources of evidence. Because in the case file he was confronted with MIT and BTK and police reports, which were very brief. If one looks at the annexes that are presented by the Turkish government on this point, these reports are only 1 to perhaps 2 pages long. And they are so vague that you cannot really challenge anything. So applicant was not in the possibility to effectively defend himself against the allegations that were held against him. The second reason that his right to a fair trial was violated is the fact that, in spite of the fact that he 4 times asked in writing, he did not obtain during the proceedings a copy of the BILOG data, while normally, under Article 134 of the Turkish Code on Criminal Procedure and Article 17 on the regulation on judicial and preventive searches, an accused automatically gets a copy of these data. He doesn't even have to ask for it. But in the present case, even in spite of your court asking for these data, nobody has received them. The third and final reason is the fact that applicants also asked on multiple occasions to obtain an independent expertise on these digital data, and he has not received this expertise. It is true that before the Regional Court of Appeals, there was an expert appointed, but in reality that was not an expert, because that man kind of made a summary of the case file in a 5 pages long document. He couldn't really make any other reflections because of the fact that he didn't get access either to the alleged BILOG communications or the BILOG data. And that was also the problem of the expert that applicant eventually assigned himself, Mr. Kilic. That man could not really make any reasonable conclusions either because he had no access to any concrete information. And so he could only conclude that the allegations were vague, that technically speaking they were conflicting, and that technically speaking they were unexplainable, these allegations and reports of the government. And just in order to show you how confusing the situation is, I want to give you one example. So the BTK and MIT reports always stated that the applicant used his BILOG application in October 2015, 6 days. But if one looks at Annex 27, the alleged communications through BILOG of applicant that are now submitted to your court, it is held against the applicant that he sent one message through BILOG, and he did so not in October 2015, but in May 2015. So that means that after all these years, we still have no idea when the applicant would have done something problematic and what exactly is in the data set that the government keeps on holding on. And if you look at all these drastic limitations of applicants' right to a fair trial, it is also clear that they are not counterbalanced by anything. The Kayseri Assize Court took applicant's case in one hearing and ignored his argumentation. The same for the Regional Court of Appeals. They initially asked to join to the case file the alleged BILOG communication of the applicant, but when that didn't immediately happen, they went forward and they confirmed applicant's conviction. They ignored his arguments and they solely relied on the alleged expert report, in reality, a summary of 5 pages of the case file. And so if you look at all these elements, this case is very different from the Rook versus Germany case of your court, because here applicant has not had any access at all to any of the relevant data or elements in this case, and it are still these BILOG data which have been the decisive point to convict him to this harsh prison sentence. Finally, it is important to emphasize that often the courts have stated that this BILOG application was exclusively used by FETÖ. But the government knows too that that assumption is not correct, In that regard, I can just refer to the Beyin incident, where 10,000 prosecutions of individuals who downloaded the Bylog app were stopped by the prosecutor in Turkey because of the fact that these people were deemed too close to the AKP party. And so there was no prosecution of 10,000 individuals who had Bylog on their phones. And furthermore, the fact that Bylog is not an irregular means of communication was also confirmed by international institutions such as the United Nations Working Group on Arbitrary Detentions, but also to some extent by the jurisprudence of your court in the Akgun versus Turkey case. And in the light of all these elements, it is clear that manifest violations of Article 6 and 8 have happened with regards to applicants. I thank you, Your Excellencies, and will now pass the floor to my colleague, Johan van der Lanotte.
Thank you. Mr. van der Lanotte, you have the floor.
Thank you very much, Madam President, honourable members of the Grand Chamber. The independence of the judiciary is guaranteed when there is no legitimate and reasonable doubt that the courts decide in an independent way. And this independence is supposed to exist. The applicant has to prove the contrary. That's the principle. The government states that the applicant raised this lack of independence of the Turkish courts in an abstract manner. We deny that, and we will prove it. We will do that by making 8 statements, 8 points, clearly showing the enormous pressure on judges deciding in the case of the applicant, and the substantial impact of this pressure leading to the absence of the guarantee of irremovability and irrevocability. Due to logical time restraints, it will not be possible to illustrate each of these 8 points with all the underlying cases. However, where needed to illustrate the point, I will give one, be a typical example. I want to emphasize that none of the numerous examples that have been given and presented to the court in the different documents, until today, none has been contradicted by the government. First point, the negative role of the High Council of Judges and Prosecutors. I will call, each time say the High Council, that's easier. Article 3 of the Decree Law number 667, in contradiction to normal constitutional guarantees, stipulates that judges and prosecutors may be not only suspended, but also permanently discharged, dismissed by the High Council without any adversarial process or investigation. The results of such dismissal is not only that the magistrate is dismissed, but also that he can never in his life, directly or indirectly, be employed in public service, even not as a lawyer. This is nothing but a social death penalty, and that without any contradictory procedure. This makes judges, notably the judges who has to decide in Gülen cases, the judges who had to decide in the case of Mr. Yalçınkaya, vulnerable. It is essential, I do not have to explain that to your court, that judges are not vulnerable when they do their duty. Due to this Article 3, they were vulnerable. Second point, this possibility is not a theoretical one. Since 16 July 2016 until 22 July 2022, when the last dismissal according to this procedure was decided, the High Council dismissed 4,360 judges and prosecutors, 20% of the total magistrates plus minus. All courts deciding in the case of the applicant were affected. All judges deciding in the applicant's case were working in a court where colleagues of them suddenly were dismissed. We should value the impact of this. If you look at this court, and tomorrow 20% of the judges disappear. What is the impact on the other judges having to decide the day after in similar cases? So, for instance, 2 judges of the Court of Cassation were dismissed. In the Constitutional Court, 140 judges in the Court of Cassation were dismissed. Third, the High Council, as we said, it is nearly absolute powers, without contradictory procedure, a dismissal. This High Council is an administrative institution. It's not a judiciary institution. The President of the High Council is the Minister of Justice, a political person, member of the government, presiding this council. The composition, logically, of the council was severely criticized by the Venice Commission, by Niels Muizenix, by the International Commission of Jurists. Fourth, it could have been a counterbalance, perhaps. In 2017, a possible appeal to the Council of State was installed against such dismissals. However, according to the communication of the Council of State itself, at the end of 2022, 5 years later, not one final decision has been taken. And the Council of State even had to apologize for the fact that 3% of the appeals, 3% were accepted in first instance, but immediately it added, it still has to be decided in second instance. This simply confirms, these 4 points, the untouchable position of the High Council in violation of the basic principles of the rule of law and the guarantee of irrevocability of judges, and more specifically, the judges who had to decide in this Yalçınkaya case, a person alleged to be a member of the Gülen movement, was inexistent, legally and in practical. Fifth, the Turkish government publicly instructs magistrates to consider the judicial corruption investigations of 2013, it was confirmed today by the government, as a coup d'etat set up by the Gülen movement. Even if proceedings in the United States prove the accuracy of these 2013 investigations, such instructions still figure prominently on internet nowadays. And the consequence, because we could say we don't have to take into account instructions, the consequence for not respecting such instructions are real and had an intimidating effect on the judges that had to deal with the case of Mr. Yalçınkaya. I will give an example to show how important these instructions and the not following instructions were, and it's a case that the court knows well. The judges, Mustafa Bashar and Metin Öçelik, released 62 police officers and 1 journalist accused, between brackets, of being a member of the Gülen movement. Immediately, President Erdogan and the High Council openly criticized the decision. May I pay your attention that the High Council criticized the content of a judicial decision. Result, the decisions were not executed. The judges were arrested. And the Venice Commission immediately criticized, stating, the facts described above clearly demonstrate that there are insufficient guarantees for the independence of the judiciary in Turkey. The case is well known. On 13 September 2022, your court came to the conclusion that in this case, Article 5, Paragraph 1 was violated. And may I pay your attention to the fact that the judgment in the this case in Turkey was used in the case of Mr. Yalçınkaya, and today is put forward as a justification of the conviction of Mr. Yalçınkaya, a case, may I remember, where the court found the violation of Article 5, Paragraph 1. To illustrate, sixth, the impact of this pressure, It has been noted in some cases that as soon as a judge is confronted with another judge taking a position even slightly favorable towards an accused who is considered to be part of the Gulen movement, completely unlawful and ununderstandable actions are taken. This is what happened, for instance, to Judge Beyit, who in no way is linked to the Gulen movement. I want to confirm that. But this Judge Beyit released 4 soldiers because he found that there was no evidence in the case file, which is his duty. 2 days later, police officers and a prosecutor entered his courtroom, the sacrosanct of the judge, took him in custody. He spent 3 months in prison. 7th, several judges questioning the validity of the bylaw evidence were immediately dismissed or subjected to disciplinary or removed. A lot have been removed. This happened, for instance, in September, September 2016 to the 3 judges of the Second Hatay Assize Court, who had critical questions on bylaw and immediately were started a disciplinary procedure. If anyone, if your court would doubt about the link between the sanctions or the removals and the content of the decisions, in several majority cases, most of all removals, sometimes disciplinary sanctions, were taken only against the judges who voted in favor of the accused, not the judges who followed the general line of the government. In such a case, not only the irrevocability, because they were not revoked, but also the irremovability, because they most of all were removed, was not guaranteed anymore to judges who had to decide, as the judges in the applicant case, about bylaw and the proof that this can be. Finally, 8th point, the composition of the 2 main courts and the functioning of the 2 main courts that had to decide in the applicant's case. We know that the Court of Cassation was completely reorganized. We will not emphasize on that. However, in July 2016, 140 judges of the Court of Cassation were dismissed. In December 2017, some months before the Court of Cassation had to decide the case of the applicant, 100 new judges were designated by decree law. When the applicant case came before the 16th criminal chamber of the Court of Cassation, 7 out of the 18 judges had been substituted by decree law. Moreover, the rules have been changed. The president of the chamber obtained completely arbitrary power to decide who would sit in the panel of 5 without rules, arbitrary. And at any moment in time, so even when the deliberation started in the applicant case, the president could remove judges and replace them by others. Even assuming that this did not happen in the applicant's case, the mere fact that it could have happened created an enormous pressure on these judges to comply with the government policies when deciding on the case of Mr. Yalçınkaya, and the trust that the accused should have in this court, of course, was non-existent anymore. The composition of the Assize Court, who had to decide in the applicant's case, also was changed. It was seriously altered. In total, 173 of the second Assize courts were removed without being asked by the judges. And a week later, this cleansed court we cannot call it otherwise, were designated to be exclusively competent for the Gulen cases. As was stated in the press, it had to guarantee the decision to be taken against the Gulenists. And especially in regards with the Kayseri'de Seas Court, which intervened in the case of the applicant, the High Council appointed a new chairman, removed a judge without his request, and appointed a new judge instead. The government claims that the applicant puts forward abstract claims. In my opinion, there is nothing abstract in this missing 4,360 judges. In my opinion, there is nothing abstract in sanctioning these persons to a social death penalty. In my opinion, there's nothing abstract when judges are arrested in their courtroom because of doing their duty. There is nothing abstract in removing judges for the same reason to another place 1,000 kilometers away, and each time judges who have to decide in a similar case as in the case of Mr. Yalçınkaya. All these facts are structural. They are concrete. They were a threatening reality in the daily life of the judges who had to decide on Mr. Yalçınkaya. They affect, in a worrying way, the independence, the possibility to decide in an independent way. And how could an objective observer, not talking about the accused, how could an observer not come to the conclusion that there is a legitimate doubt about the independence of the courts and the judges having judged the case of the applicant? Shortly about Article 11. We have different positions from the government. We saw that they sometimes say, yes, but the adherence to the associations and to the union has not been decisive. It was only something, I quote the summary, a factual circumstance that supported the conclusion. That's in the last summary of the government. I only will cite what the judgments say when the court has to decide if the applicant effectively was part of the hierarchical structure of the terrorist organization. The court states, on the ground that he was a member of multiple associations and trade unions, and that he used the ballot application. The fact he was a member of this union and member of this association has been taken in account as a substantial reason for the conviction and is, I cannot say it otherwise, a violation of Article 11. As far as Article 7 is concerned, the applicant reiterates that the decision of the Court of Cassation on 24 December 2008 is very important to assess the situation of the applicant. In 2008, the court decided that the Gulen movement was not a terrorist organization, and the applicant could rely on that. That was the only decision that was known. To be honest, it's not because the government of the corruption cases in 2013 says that this is a kind of a terrorist act, that it is. The only official institution that called the Gulen movement a terrorist organization was the National Security Council, and that was in June 2016, not before. Before, we had the parallel state, sometimes called by the government, but that doesn't show anything. Everyone can say for a political opponent that he's a parallel state, but the term terrorist organization is the first time in June 2016 in the National Security Council. May I remember that all the facts where the applicant is accused for are prior to that period. Only his membership of the union was a bit longer, and we can state in June it is said that it is a terrorist organization. In July, 2 weeks later, he stops his membership of these associations, as is in the document. Were there convictions that were, in his conviction where judgments were referred to? Yes, judgments posterior to the facts. So, the mental element the basic element of each crime, that the applicant knowingly and willingly was member of a terrorist organization, clearly is not present and has not really been examined. Although your court is not a fourth instance court, we do not need to be remembered on that. The court, however, cannot deny that the alleged but denied conversations on BILOG, so important, in no way are related to anything that has to do with terrorism. Nothing, not one word. Taking into account these elements, we cannot conclude otherwise than that Article 7 in this case has been violated. Thank you.
Thank you for your submissions. I now invite the judges of the Grand Chamber wishing to do so to put their questions to the parties. Judge Ravarani.
Thank you very much. One very short and easy question to the applicants. I don't know whether they want to respond to it. Is it the applicant's position that he used or that he didn't use BILOG? Thank you very much.
Thank you. Judge Yüksel.
Very much related, similar question, because from also to the applicant, but of course if the government wants to comment, they can wish to do, if they wish to do so. But from my understanding of the observations in the submissions, there is a fact which is contested by both parties. So the applicant denies that he has ever downloaded or used BILOG, and then the government contests this. So in this case file, the following submissions have been adduced regarding the use of BILOG. So the finding of the assize court, based on reports obtained from relevant authorities, that the applicant had used the application on his GSM line from October 3rd, 2015 onwards. The finding of the expert report on the HTS and CG0 data requested by the Regional Court of Appeal that showed the applicant had connected to the server 380 times over 6 dates. So taking all into this account, as Judge Ravarani, I wonder the view of the applicant. So I'm just trying to understand if the applicant is suggesting that this court should set aside these findings. So thank you.
Thank you very much, Judge Yüksel. Judge Derinovic.
Thank you. I have a question for both parties. Would you please clarify the way the applicant obtained the BILOG on his mobile phone? Was it by downloading or in some other way? If you could clarify this issue. Thank you.
Thank you. Judge Semachkova. Microphone.
I have a question to the representative of the government, if they can comment arguments about the lack of independency of justice and of the court deciding about the case of the applicant. Thank you.
I look to the judges to see if there are any further questions. If not, the court will now withdraw for 20 minutes, reconvening at 10:50, following which the parties will be able to submit brief observations in reply to each other's submissions and also in reply to the questions posed by the judges. Thank you very much.
La Cour.
Please be seated. The hearing is resumed. I draw your attention also to the fact that the judges will have the possibility, after hearing the answers to your questions, to ask for additional clarifications concerning those answers if they see fit, without, however, asking new questions. I give the floor to the government.
Thank you, Madam President, members of the court. We have heard a rather fact-based presentation by counsel opposite. The government generally objects to the facts presented. We do not have the time to point out all the misleading statements. I just want to highlight one. Counsel opposite, for example, claimed that the BILOG application had been downloaded 600,000 times. This is grossly misleading. The reports have established, and even reports accepted by the applicant, that there are just 215,092 user IDs, and that about 100,000 persons used the application. So speaking of about 600,000 creates a wrong image. I would invite the court to consult especially the decisions of the Turkish courts, where the facts are laid out. And I would also like to draw your particular attention to the minutes of the hearings of the Assize Court and the Ankara Regional Court of Appeal, because in these minutes you will also find decisions of the court you will not find in the final judgment, decisions with regard to procedure. You will also find in these minutes expressly recorded that the applicant has been reminded, for example, and I quote from the minutes of the hearing on 9th October 2017 before the Ankara Regional Court of Appeal, that the applicant may request collection of the concrete evidence to clear himself from suspicion, that he is provided with a possibility to remove the causes of existing doubts against him, that he may raise the points which are in his favor, and that he has a right to request more time to prepare a written defense. The applicant has not availed himself of these opportunities because his main line of defense was that he did not use BILOG. For that reason, at the time, he did not engage properly with the BILOG evidence. The applicant's counsel also raised the question of the authenticity and accuracy of the data. Again, if you turn to the decisions of the court, you'll find that the courts expressly dealt with the question of the reliability of electronic data in general and the authenticity and accuracy of the BILOG data. So the question was before the courts considered it, and the courts considered the BILOG data at the time reliable. I now turn to the questions by the honorable judges. Judge Drenjinovic asked how BILOG was obtained by the applicant. The simple answer is the government does not know. Not just in the case of the applicant, in none of the uses. Bylog can be acquired either by way of downloading the application from an application marketplace, like an app store. It could be transferred via Bluetooth. You could install it using a memory stick, or you could transfer the relevant data via a personal computer. So there are various ways. There is, however, one way to find out, at least with regard to one of these options, namely downloading it from the App Store if you have the mobile phone to which it was downloaded. Now, the applicant did not cooperate with the judicial authorities and did not hand over his mobile phone. So it could not be detected of whether he downloaded the application from an app store or whether he got it by other means. With regard to Judge Simakova's question regarding the lack of independence of the judiciary, we've heard a lot of general statements by counsel opposite, general accusations of pressure, of structural deficits, of vulnerability of judges that have been dismissed. Counsel opposite spoke, and I quote, of the independence of the judiciary in Turkey in general. But this is not a case about the judiciary in Turkey in general. It is, if I may quote Article 6 of the Convention, it is about an independent and impartial tribunal, namely the Second Assize Court in Kayseri and the Regional Court of Appeal in Ankara, the relevant chamber there, and the relevant chamber of the Court of Cassation. When I was going through the documents, I was struck by the fact that nowhere in the documents I could find the names of the judges involved unless I was looking at the decisions itself. So there was never ever any accusation of partiality or non-independence against an individual judge involved in these cases. So again, I would refer you to our earlier submissions that this is not about the judiciary in general, it is about these judges specifically. If you were to rule on the basis of the allegations made by counsel opposite, then all Turkish courts would no longer be considered impartial and independent. Every single Turkish court decision could be challenged before this court on the basis of the statements made by counsel opposite. That surely cannot be the case. I thank the court for its kind attention.
Thank you. I give the floor to the applicant's representatives.
Madam President, honorable members of the court, dear judges Derincinovic, Yüksel and Ravarani, I thank you for your questions. To briefly answer that question, the position of the applicant is that he did not download the Bylog application or not use the Bylog application. And therefore we claim three things. One, that the reports and documents that your Honorable Judge Yüksel referred to, that they are fabricated. Two, at least they are internally conflicting. And that is what I was explaining in my pleading, is that the documents submitted before the domestic courts state that applicant had his alleged criminal communications in October 2015, while the documents now submitted to your court, Annex 27, on the very last page, you will see that the only criminal communication that they allege the applicant has made dates from the 20th of June 2015. So a totally different time period. And so that is the point that we have made. The third point is that the only way for the applicant to show that he did not download the Bylog application would have been to access the original Bylog data. And then it would have been clear. Either there is a reliable chain of custody and one can clearly see that he is the one who downloaded the application or not. The government, even up till today, does not seem to know how the applicant would have done so. And that opportunity the applicant did not get. And that is so manifest that we do not ask your court to be a fourth instance, but that this concerns really general principles under Article 6 and 8 of the Convention. Perhaps a few short things I want to say in reply to the statements of the government regarding the users of the BILOG application. I just refer you to Annex 40, page 46 of the documents submitted by the government themselves, in which reference is made to an MIT technical report stating that there were more than 513,000 users of the BILOG application. So I don't think we have said anything that was not correct in that point. And lastly, as to the authenticity of the data, the government states that this authenticity was verified by the courts, but I wonder how can a court verify the authenticity of data if even today they are not able to say whether the applicant downloaded or how he downloaded the data. The judges, the domestic judges, did not have access to any information that allowed to verify or say something credible with regards to the authenticity of the alleged BILOG data the applicant has used. I will now briefly pass the floor to my colleague with regards to the points on the independence. Thank you.
If ever that would be a misunderstanding, but I don't think it is, I was not pleading the lack of independence of the Turkish judiciary. That I have not been saying that, and I have not been pleading that. But I was pleading that the judges deciding in the Yalçınkaya case, specifically I was more oriented what the Court of Cassation and the Assize Court were not in the possibility to decide in an independent way, because the court they are member of was cleansed. 140 of the members of the Court of Cassation, the 16th chamber that decided on the case of Assize, 7 of 18 were replaced, 7 on 18. That's not a general element, that is a factual element. And knowing that all this could happen in a context where unilateral, without contradiction, judges could be dismissed, which in reality happened, and that even no real appeal to the Council of State was possible, these judges in this specific context, knowing also that in the Court of Cassation the rules have changed, with the President having a discretionary power even during deliberations to change the composition of the panel, it's made that a normal human being as a judge was not free from fear. A judge who has to be afraid of what could happen without contradiction, without appeal, a judge who has a fear from what could happen can never be considered by the accused and also not by an objective observer to be independent. That was the basic element, and that has nothing to do with the judiciary in globally, which I was not pleading about.
Thank you very much. We've now come to the end of the hearing. I thank the parties for their submissions and for their answers to the judge's questions. The court will now deliberate on the admissibility and the merits. The judgment will be delivered later and the parties will be informed of the delivery date. I declare the hearing closed.